Hello, Iowa REALTORS. I'm Eric Malloy, your 2026 president, and I'm here with Justin Hayes, our legal counsel today.
Hey, Eric.
How are you?
Good. How are you?
Let's talk about radon mitigation and adverse facts.
Okay.
Material adverse facts.
Yes. Important.
What do our members need to know about radon testing and mitigation?
All right. So, look, as it stands, maybe it'll change in the future. You don't have to test for radon. There's no legal requirement regarding testing for radon at the state level.
Okay.
There's also no legal requirement regarding mitigation. There is a legal obligation to disclose the existence of previous radon tests
Okay.
on the seller disclosure.
So if I own a property and when I bought it, I did a test, let's say.
Yep.
I have to disclose that
Yes.
on the disclosure.
Yes.
Okay.
Yep. That is actually one of the questions on the state's modeled seller disclosure and the administrative rules.
Okay. So it is on the state form.
It's on.
In administrative rules, but if you create your own disclosure, you need to make sure that you have a section in there that asks
Yes.
about radon and if it's been tested previously.
They will run you through the questions that have to be on your seller's disclosure. So if you create your own form, you have to meet those minimum requirements and hit those those minimum notes, right? And then if you go beyond that, you go beyond that. That's at your discretion. But that's one of the questions that they ask you on that form.
Okay. So what is a material adverse fact?
Yeah, so I'm going to read the definition from the code. This is important. So an adverse fact that a party indicates is of such significance or that is generally recognized by a competent licensee as being of such significance to a reasonable party that it affects or would affect the party's decision to enter into a contract or agreement concerning a transaction or affects or would affect the party's decision about the terms of the contract or agreement. That's from 543B. And then there's a subsection here, presenting a significant health risk to occupants of the property. And that's where radon comes into play, right? So let's say you're buying a house, right? And I, as a seller, you requested that I have a radon test done. I don't have an obligation to do that, but if we negotiate it and I choose to have the test done and we agree to that, then once that test comes back, even though there's no obligation to mitigate, there is now going to be an obligation if that test is above the minimum legal limit for radon and the property to disclose that, because that becomes a material adverse fact.
Okay. So what, as a licensee in the state of Iowa, what is my obligation in regards to disclosing radon and, informing our clients?
Absolutely. So we've changed your role from buyer of the property to my licensee, right?
Okay.
So now the test is done. I know that the test is above the limit. You know the test is above the limit. If I'm unwilling to disclose it, you still have to disclose it. You still have that obligation because it's a material adverse fact. And you have to disclose things that are known by the only things you don't have to disclose would be things that are known by the party, so known by the buyers, if they've run the test and they have the information about the results of the test, or those things that the party could discover through reasonably diligent inspection, those things where the disclosure of which is prohibited by law, or those things that are known to a person who conducts an inspection on behalf of a party. If it doesn't fall into one of those four subcategories, you have to find a way to pass that information along. That's your legal obligation under the code.
Okay, so if I'm representing the seller, buyer tests for radon, it comes back high, the deal falls apart, whether it's because of that or something else, and we move on, keep it active on the market, we get another buyer, or even before that, what is my obligation now that I know as the listing agent that we have a high radon test?
So the first thing is you got to instruct your seller to update their seller disclosure regarding the existence of that high radon test on the property. Excuse me. Again, that becomes a material adverse fact that needs to be disclosed to all prospective buyers moving forward. And then also you as the licensee have that same knowledge of the high test, so you have an obligation to ensure that disclosure is completed, and if it's not completed by your client, it has to be completed by you, which can put you in a tricky situation, I fully admit, but ultimately the law requires what it requires, and that requires, in your case, disclosure of all material adverse facts of which you have knowledge.
Okay, so I tell my seller they need to update the property disclosure with this information. They are refusing.
Yeah.
But they still want to work with me. We still have an active listing agreement. When I get showing requests, it's my obligation to inform the buyer's agent that there is a high radon, even though it's not on the disclosure, because I can't fill out the disclosure for the client.
You can't.
They're refusing to do an update for whatever reason. But I still have that obligation to share that information with the other agent, correct?
I would say yes.
Okay.
I would, because again, it becomes a material adverse fact, and I don't know that this would fall in the scope. Well, okay, so this wouldn't fall in the scope of like information known by an inspector, which is one of the exemptions, right?
Yep.
So we're going to waive that off as an exemption. This is not information that would be known by prospective buyers, so we're going to waive that off as an exemption. They could potentially discover it through diligent inspection, but that's probably going to require another radon test be done, right? Or at least the results of the radon test be passed along to them. Like, there's not really a way to know that there's high radon on the property without seeing test results from a radon test. So probably not going to fall within that exemption. And then the disclosure of which is prohibited by law, the disclosure of a high radon test, as far as I'm concerned and as far as I'm aware, is not prohibited by law. The only argument would be client confidentiality, but again, and we've actually touched on this, not you and I, but in a previous video we talked about the like weighing confidentiality against the disclosure of material adverse facts, and I think the result is that disclosing those material adverse facts at times can outweigh the client confidentiality obligation.
Okay.
So you got to find a way to disclose it. You got to find a way to get that information over to any prospective buyers, because it is a thing that could affect their decision to purchase the home.
Okay. Give us a quick recap of the rules and obligations in the state of Iowa, what we just covered.
For sure. So at this point, when it comes to resales, they're at the state level, because they could be different rules in like different counties and municipalities, right? There's no obligation to conduct radon testing. There's no obligation to mitigate radon testing. There is an obligation. There's no obligation to mitigate radon unless the radon's in excess of the minimum required level, and then there can be an obligation to mitigate because it's a material adverse fact that has been disclosed, right?
Okay.
But then also there is an obligation to disclose the existence of radon tests on the property. Like, that has to be on the disclosure. So even back to your situation, just real quick, where the seller doesn't want to update the disclosure. So your seller is creating a horrible, horrible situation for themselves, because there is this test that exists that multiple people know about, right? So if they don't want to update the disclosure, honestly, your best option might be to just walk away from that situation.
Yes. Yeah.
But if
I doubt this will happen very often, but sometimes sellers can be stubborn and they just don't want to disclose for whatever reason.
Yeah, you got that right. So yeah.
Okay. Anything else?
Last thing. The rules for radon may be changing.
Of course. Why wouldn't they?
In particular when it comes to new construction. And so, fortunately, in-house, we have our Government Affairs Director, Greta Haas, who can give you an update on those changes when they take effect.
All right. Stay tuned for an update from Greta. Thank you.